Welcome to everyone who is joining us on this Tuesday in June. We have a packed program for you today, a couple of updates on recent guidance issued by the Department of Labor and the New York State Department of Health. Before we get into that, I want to go over our weekly COVID update to see how we are doing. Next slide, please, Kathy. So I am happy to say that after weeks and weeks of bad news, the news is starting to look a little better in New York State. As you can see here, we are seeing the chart is going in the correct direction now. Case numbers, positive tests are going down. You see that our 14-day change is approximately 35% in the correct direction. Hospitalizations are down, ICUs down, deaths are down. So these are all good numbers, good indication. Now we saw, interestingly, when we went through this most recent spike, the governor didn't take any significant action. We had seen in the past 2 years that when there would be a spike, there would typically be some kind of reaction from either Department of Health or the governor's office imposing some additional restriction, whether it be in masking or other restrictions. Here, this time, we didn't see that. So maybe that is an indication of what we can expect going into the future. Next slide, please. Again, I'm happy to present these graphs. The New York State picture looks a lot less red, which is what we had been seeing for the past month and a half. Some areas, including Central New York, you're seeing even the light, very light yellow. Great numbers. All of the numbers on the right side of the chart you see there are negative. Again, all positive indications that we are through this particular wave of COVID in New York State. So that is our COVID update. And branching off of that COVID update, we are going to have a presentation on updated guidance from the New York State Department of Health as it relates to isolation and quarantine periods. We haven't seen an update on this guidance for several months. So here to talk to us about that today is Hannah Redmond. Hannah is an attorney in our Syracuse office. You all have seen Hannah on these presentations before. Hannah, thank you for joining us.
Thanks, Adam, and hello, everybody. Like Adam said, today I'm going to give you a quick update on new guidance from the Department of Health on quarantine and isolation periods. Kathy, can you go to the next slide, please? So on May 31st of this year, the Department of Health issued updated quarantine and isolation guidance. This updated guidance replaces the prior iteration of the same quarantine and isolation guidance from March of this year. The May guidance is very similar to the March guidance. We've seen very few changes in the update. The most significant change is a new quarantine and isolation exception for children in childcare and early childhood education settings. The new guidance also groups all individuals who are age 5 and up into the same quarantine isolation periods. You're all probably familiar with the idea that quarantine periods under the March guidance were based in part on vaccination status and age. That's due to the fact that the vaccination is not yet approved for all ages. The prior guidance spoke to 4 age groups: children under 2, children ages 2 to 4, children ages 5 to 11, and then everyone age 12 and older. The new guidance eliminates the 5 to 11 age group and groups everyone into a 5 and up age group. So the result is that the quarantine guidance is the same for everyone who is 5 and up, dependent, of course, on their vaccination status. Next slide, please, Kathy. This slide shows the quarantine guidance from March of 2022. So this is the prior guidance that was just superseded by the new guidance, which we're going to talk about in just a minute. You'll notice that this table shows the 4 age groups I mentioned in the first row. I wish I had a laser pointer for you all, but in the top row, you'll see the age groups under 2, 2 to 4, 5 to 11, and then age 12 and up. Hitting on the highlights just to refresh everyone's memory, you'll recall that under this guidance, those who are fully vaccinated and up to date on their boosters do not have to quarantine due to a known exposure to COVID-19. Those who are unvaccinated and not fully up to date on boosters are subject to a 5-day quarantine period and testing on day 5 or when they're symptomatic, whichever is first. And then those under age 2 are advised to quarantine for 10 days. These basic guidelines have not changed as a result of the May update. As I mentioned, we didn't see many substantive changes in this updated guidance. Next slide, please. This is the new table from May 31st. So this is our updated guidance. I highlighted the relevant portions that have changed. So even just looking at this picture, I know it's a little bit hard to see on the slide here. You'll see that there aren't a ton of changes. There's really three major areas that have changed. The first is the consolidation of the 5 to 11 age group into the 12 to adult age group. Like I mentioned, the rules for that age group have not changed. So everyone 5 and older is dealing with the same basic structure in terms of quarantine periods. But the more significant change is on the left-hand side of the screen. And this is the quarantine exception for children in childcare and early childhood education settings, aka children who are ages 0 to 4. And this is the population of people who are not yet eligible for vaccination. Next slide, please. So this is a new exception for children ages 0 to 4. The guidance provides that children who are 0 to 4 who have a known COVID exposure may attend childcare and school on day 6 if they are completely asymptomatic. So there's still a 5-day quarantine period for this group of individuals, and testing on day 5 is recommended but not required. Masks are not recommended for children who are under the age of 2, so they do not have to mask, but for children 2 to 4, masks should be worn on days 6 through 10. Kathy, can we hop back to slide 3 for just a second? So looking at the first 2 columns where there are highlights, if you look at the quarantine duration portion of the column, you'll see that there are different rules for children who are under the age of 2 as compared to children who are ages 2 to 4. Children under 2 are advised to quarantine for 10 days, but they can attend childcare or an early education setting on day 6. So the guidance expressly provides that even though they're subject to a 10-day quarantine period, on day 6, there's this exception limited to attending childcare or an early childhood education setting. The guidance from the Department of Health expressly provides that children under the age of 2 must continue to quarantine as otherwise required outside of the childcare setting. So on day 6, children under 2 can essentially break their quarantine, go to childcare, go to their early childhood education setting, and they must otherwise quarantine. So it's limited to those settings. And then children ages 2 to 4 are only subject to a 5-day quarantine period. So they can return to school and childcare on day 6 if they're symptom-free, and they do not have to quarantine in other settings. We can go back to slide 4, please. Thank you. And then for staff who work in childcare and early childhood education settings who are not vaccinated or are not up to date on their boosters, the standard rules apply. So they can return to work on day 6. They're strongly recommended to test on day 5, and they can return to work if they're negative. If they test positive, they should isolate for 5 days under the isolation guidance. And if testing is not available, they can still return to work as long as they're completely symptom-free. And then, like children ages 2 to 4, masks should be worn from days 6 through 10. Next slide, please. The quarantine table from May of this year was also updated to reflect the CDC's May 24th definition of up to date. According to updates from the CDC on May 24th, you're up to date with your COVID-19 vaccinations when you've received all doses in the primary series and all boosters recommended for you when eligible. Eligibility and recommended vaccination or booster series is dependent on age, which vaccine you first received, and the date of your most recent dose of the vaccine or booster. The CDC's May 24th update goes through the various variations of recommended vaccinations and boosters, and all of that information is accessible at the link on this slide. Next slide, please. On this slide, you'll see the March 1st guidance for isolation. Again, this is the prior guidance that has now been replaced. You'll remember that isolation is for those who have tested positive or become infected with COVID, whereas quarantine is for those who have been exposed but are not positive. So this is separate guidance. Isolation is the same for everyone, regardless of age, vaccination, or booster status. And just to give a brief refresher on the isolation guidance, people who are asymptomatic but have tested positive should isolate for 5 days and wear a mask on days 6 through 10 when around others. If they cannot wear a mask on days 6 through 10, they should continue to isolate for a full 10 days, and testing on day 5 is optional. Those who are symptomatic and positive should also isolate for a minimum of 5 days, and they can end the isolation period when they are fever-free for more than 24 hours without the aid of fever-suppressing medication, and when their symptoms have begun to improve. And the same rules apply. They should mask on days 6 through 10 and continue to isolate through day 10 if they are unable to do so. Next slide, please. This is the May 31st table. You'll see, again, not a ton of updates, but the highlighted portions are what has changed under the new guidance. This table was really just updated to include language about a new isolation exception for children attending childcare and early childhood education settings. Next slide, please. And on this slide, the new exception for isolation in those settings is laid out. Children and staff should isolate per the normal rules, subject to a few exceptions. So under the new guidance, children who are ages 0 to 4 can return to the childcare or early education setting on day 6 if they are fever-free for 24 hours or more without the aid of fever-suppressing medication, and if their other symptoms are improving. So that's the same rules under the general guidance for the general population. Testing on day 5 again is recommended but not required. And if someone tests positive on day 5, they should remain in isolation through day 10. For children who are older than 2, a mask should be worn on days 6 through 10. And under the new isolation exception, children under 2 can still attend school on day 6, even though they can't mask. So we know under the regular isolation rules, a mask should be worn on days 6 through 10, and those who can't wear the mask should remain in isolation. However, this exception allows children who are ages 0 to 2, who are not recommended to wear masks, to attend childcare or school on day 6. Like the quarantine guidance, those children should isolate in other settings. So it's limited to childcare and school. So it really is a very narrow exception that this new guidance is creating, both for isolation and for quarantine. And staff can return to work on day 6, and the same rules apply as for the general population. So overall, the May guidance is very similar to the prior guidance, which is fortunate for all of us. There's not a ton of new information to learn. The only substantive changes really relate to this population of children who are ages 0 to 4, who are attending childcare or early childhood education settings. And the exceptions are limited to those settings. And that's all I've got.
Thank you, Hannah. You know, one of the interesting things in this new updated guidance is the change from 12 and above to 5 and above. And that is to reflect the CDC's recent recommendation that children 5 and above can get a booster shot 5 months after they receive their primary series. So that's something to keep in mind as well. All right, next up, we have Teresa Rusnick. Teresa is an attorney in our Rochester office and has been on many times before. Teresa is here to talk to us about DOL audits. I know Teresa has undergone a number of these with her clients recently. So Teresa, welcome.
All right, thanks, Adam, and hi, everyone. I am going to be indeed talking about DOL audits, or Department of Labor audits. So let's start with who is doing the auditing. I'm talking specifically today about the Federal Department of Labor, because those are the most recent couple of audits that I've had within the past month and a half. New York State, of course, can audit employers as well. But sticking with the federal side of things, generally speaking, an audit happens either on the department's own initiative, so they can say, I'm going to audit a particular industry or a particular company, or it can happen after a complaint is made. Generally, they will not tell you what complaint has been made or who made it. But that's how DOL gets involved. It's either, been marked for them to audit you through some complaint process, or the industry has, come under target umbrella by the Department of Labor, or, who knows how they do things over there. But either way, you get picked for a Department of Labor audit. And during the audit, they're primarily looking for compliance with the Fair Labor Standards Act and a little bit with the Family and Medical Leave Act. But mostly they're looking for wage and hour type compliance with the Fair Labor Standards Act. So that's what we're going to talk about in the next couple of minutes. Next slide, please. So Practically speaking, when the Department of Labor audits you or decides to do an inspection in your workplace, they're going to notify you of the date that an inspector will come on site. During COVID, we had a couple of these done virtually with the inspector on video call, but generally they would be on site. The investigator will begin with an opening conference and end with a closing conference. Ideally, you'll know the results of their investigation that day. In my experience, that does not usually happen. Usually there's additional paperwork that needs to be given, records that need to be interpreted, and people that need to be talked to. So it doesn't usually end that day, but it is supposed to end shortly thereafter. The investigator will speak with supervisory and non-supervisory employees. They may do a visual inspection of mandatory posters or request that you send them a picture of the mandatory posters and where they're posted. In terms of your rights as an employer, you have the right to have an attorney present for each aspect, except for the interviews with non-supervisory personnel. So when your supervisors are being talked to during the opening conference, during the closing conference, whenever that occurs, you have a right to have an attorney there. You do not have the right to have an attorney there when the Department of Labor is speaking to your non-supervisors. And let me go to the next slide and we'll talk about what the DOL is there to look at. They are there to look at your records and talk to your employees and make sure that your records comport with the employee's experience. And that is particularly true with your time and payroll records. They are going to be at the center of any DOL audit or wage and hour litigation, which we'll talk about a little bit more in a minute. In general terms, the Fair Labor Standards Act doesn't specify the form in which your records must be kept, but you must be able to convert the data into a form that can be viewed and inspected within 72 hours. You must maintain records for 6 years, so make sure you're keeping your payroll and timekeeping records. Again, that's not just for the federal government, that is for New York State as well, especially on the 6-year requirement there. So you want to make sure that you're keeping your payroll and time records. Do not throw them out. Make sure you've kept those. They're going to be the center of any DOL audit. And let me go to the next slide before I talk about private litigation. So here are some of the things that have been requested in the more recent audits that I've been a part of. So payroll records for all employees for the past 3 years, timesheets for all employees for the same period of time, names, addresses, and phone numbers for all employees at the target location, a list of all exempt employees at the location, their exemption, how the exemption was determined, and a brief job description, independent contractor arrangements, any information on child labor or employing people who are under the age of 18, and then your FMLA policies and procedures and your timekeeping policies and procedures. So those are just some of the categories of documents that DOL may ask for. I took a look at one of the more recent letters last night, and it was something like 18 categories of documents. I've highlighted some of the more pertinent ones, or the ones that tend to encompass a couple different areas. But they have a broad basis to ask for documentation, and they use that. What they'll do with this documentation is they'll look at it to make sure that you're paying people correctly for the most part, and then they'll either call your employees or talk to your employees and make sure that they're receiving appropriate time off, that they're receiving the right wages, that they're being paid for all the time that they actually worked, that there's not off the clock time being left out here. And so those are the kinds of things that you can expect in a DOL audit in terms of what they're going to be looking at. One of the things I will highlight here, and I think I talk about it a little bit on the next slide as well, but is that bullet in the middle, which is the exempt employees, their exemption, how the exemption was determined, and a brief job description. This is my PSA to all of you. If you do not know why your exempt employees are exempt, or you think that there may have been some changes to their job description or to their wages that might change their exemption status, I implore you to please look at that before the Department of Labor decides to audit you, and not after. After, it's a little bit too late. We can't, if I'm going through this process with a client and I see someone who probably shouldn't be exempt but has been classified as exempt, I can't then put the toothpaste back in the tube and change the exemption at that point in time. This is also all of this stuff, but especially the exemption issue is critically important for any private sector litigation as well. You know, if an employee who's supposed to be non-exempt has been classified as exempt, they may have a cause of action for unpaid overtime, unpaid minimum wage, time off the clock, etc. And the penalties in a private action can be very high and usually, frankly, higher than at the DOL. So there's multiple reasons to make sure that your records are correct. not the least of which is the Department of Labor. Next slide, please. So how can you prepare? As I've been saying, make sure your exempt employees are truly exempt. Make sure you're complying with minimum wage and overtime pay laws. Again, I'm talking about federal, so you want to make sure you're complying with federal. To the extent that you're also in New York State, their laws are a little bit different. You want to make sure that you're complying with both the state and federal laws with regards to both of those things. You want to make sure employees are not working off the clock and that your time records are accurate. If your time records are not accurate, they are not useful to you. I can tell you from experience that the Department of Labor or a judge is going to believe the employee because it's the employer's obligation to keep accurate records. And if we don't have accurate records, they're going to believe the employee when the employee says, I worked XYZ times on XYZ day. One thing I will caution everyone on, and this could perhaps be a separate presentation, but if you have automatic meal period deductions, I'd urge you to really look at that system. That is something that I've seen get a number of employers in trouble because employees can then claim that they worked over the lunch period or the meal period, and we don't have records saying, no, they actually signed out at this time and signed back in at this time. We just have an automatic deduction for everybody, and that can be very problematic in a wage and hour context. Should you conduct an internal audit? You certainly can. It's certainly something I'd encourage you to work with counsel on. For the basic reason that if you work on an internal audit with counsel, you are able to keep some of the violations that might be found in the realm of attorney-client privilege and not something that would have to be disclosed in a later lawsuit or handed over to the Department of Labor. So that's my 30,000-foot overview on Department of Labor audits. They have been happening, in my experience, a little bit more lately. So if you get a letter from them, this is kind of what you can expect, and you frankly don't even want to get to that point. So make sure your ducks are in a row with regards, especially to your payroll and timekeeping before that happens. So Adam, I'll turn it back to you.
Teresa, thank you so much. Great practical advice. We represent lots of employers who get these DOL audit notices, and invariably they turn into some private litigation that could cost your company a lot of money. So great practical advice, Teresa. Thank you. Okay, next up. So the Department of Labor also recently provided some updated guidance for FMLA leave that we thought would be helpful to bring to your attention. So it is currently Mental Health Awareness Month. So the Department of Labor took this opportunity to issue some additional and new guidance regarding mental health conditions as serious health conditions that would entitle someone to FMLA leave. So by way of review, FMLA leave is 12 weeks of leave that is available, unpaid leave available to certain eligible employees who work for eligible employers. Basically, the employee has to work for 12 months, have at least 1,250 hours of service during the 12-month period prior to the leave, and work at a location where the employer has at least 50 employees within 75 miles. So that's just a little background on FMLA eligibility. This new guidance that came out on May 25th says a couple of things with respect to mental health conditions. First, it says that mental and physical health conditions are considered serious health conditions under the FMLA in two circumstances. Number one, if they require inpatient care, or number two, if they require continuing treatment by a healthcare provider. Inpatient care is defined as at least a one-night overnight stay at either a hospital or a mental health institution that provides care to an individual. Continuing treatment is defined as a condition that incapacitates an individual for more than 3 consecutive days, or a chronic condition that causes occasional periods when an individual has to seek treatment for at least 2 times per year. So the guidance provides a little more clarity on mental health conditions and when they can constitute a serious health condition under the FMLA. The guidance is very helpful because I think, at least I've seen in my clients, an increase in the number of mental health related FMLA claims. So this guidance provides some good information for employers as they navigate those tricky waters. The guidance also talks about FMLA leave to provide aid to an individual's family member who is also suffering from a mental health condition. For example, providing care for a spouse, child, or parent, including children who are over 18, who are unable to care for themselves due to the mental health condition. There's an example provided in the guidance of an individual, a child who is over the age of 18, who is just recently released from an inpatient facility and is unable to care for themselves. The guidance says in that circumstance, the employee would be entitled to FMLA leave. The guidance also highlights a couple of things that you all know relating to keeping medical information separate from your other employee records, and also not retaliating against individuals who seek or take FMLA leave. So that's just a quick overview of the updated FMLA guidance as it relates to mental health conditions. We also have a blog post on the Schoeneck King Labor and Employment blog on this updated guidance. If you have any questions, feel free to take a look and reach out to the labor and employment lawyer who you typically deal with for any questions. Okay, next up, we have the latest in our installment on various labor and employment topics from the lawyers who wrote the book on New York labor and employment law. I don't need to introduce them anymore because I'm sure you're familiar with them. It's Jeff Keel and Lou DiLorenzo. Today, they have another really great topic that we think will be very beneficial to you. I just talked about FMLA leave. Jeff and Lou are going to talk about another issue relating to leave, and that is reasonable accommodation. So Jeff and Lou, welcome back and take it away.
Okay, thank you, Adam, and good afternoon, everybody. Lou and I are going to talk about reasonable accommodation with the caveat that this is way too big a subject to cover in 20 minutes. So we are going to touch on the high points with the basic idea that this will be a refresher course for all of you and also something to get you started. I think I need to point out that in addition to the statutory basis in the Americans with Disabilities Act and the New York Human Rights Law, these laws are constantly being interpreted and reinterpreted by the EEOC, the New York State Division of Human Rights, and local human rights agencies. So when things get dicey, it is important to check with counsel as to what you're doing. But in the meantime, there are some things you should look at. Now, the ADA was first passed in 1990, and it has done two things that are very significant from a human resources perspective. The first thing it did was it opened up the workplace to many people who had been excluded or limited because they had disabilities or were perceived to have disabilities, which really didn't keep them from working. The second thing it did, and many of you will know this, is it has empowered surprising numbers of employees to drive human resources administrators to the brink of gibbering insanity with insane demands. The trick here is to get rid of the latter without violating the rights of the former. And there actually are some rules of thumb that you can follow that will keep you safe, as well as weeding out the frivolous complaints. I guess the place we need to start is, what is a disability? There are lists under state and federal law of what is automatically a disability, but generically, a disability is an impairment or the perception of an impairment, which might limit somebody's qualifications and ability to perform a job. And the might is the important part. But before we get to the might, I do need to point out that not every disability is a protected disability. A protected disability, and this is pretty much a mantra, is a disability which does not prevent the individual from performing the essential functions of the job, either with or without reasonable accommodation. Now, what does that mean? Let's take my friend who has very limited vision. He's about 2,400, which is certainly legally blind. Is he ever going to pitch for the Yankees? No. Insofar as that job is concerned, it is simply not a qualified disability. If you can't see the batter, you can't throw the ball. Is he qualified to work as a tax attorney? Well, you might say, hey, he's going to have to use a computer. How will he see the screen? The answer is there is software which can read what's on the computer, and someone who's learned to touch type can hear back what he is writing on a computer. And there's an awful lot of stuff that is available. So that is somebody who can perform the basic functions of being a tax attorney. Now, an employer might say, well, that's all well and good, but our attorneys are also expected to engage in business development, and we play a lot of golf with our clients. It's basically our central method for cementing client relationships and finding new clients. How is your friend ever going to play golf? Well, the answer is that he isn't, but it's not an essential aspect of the job. So in evaluating a disability, you really need to make the distinction between what is essential and what is inessential. Some disabilities are obvious. If a job applicant comes to your office in a wheelchair, that's probably a pretty obvious disability. If a job applicant happens to suffer from an intermittent seizure disorder, you're not going to know that. And the question becomes, at what point in the hiring process is it appropriate to ask about a disability? If the disability is obvious and clearly related to the job, you could do it pretty early on, but the safest rule here is not to inquire about disabilities until after you have decided to make a conditional offer of employment. And if you remember our discussion that we had a couple of weeks back about criminal records, this is essentially the same thing. First, decide whether, based upon what you're seeing in this person, he or she can do the job. Ask about the possibility of disabilities later. Now, let's use the person who comes in who is wheelchair bound. Maybe this person is interviewing for a telephone lineman's job. It would be legitimate, I think, to ask that person how she's going to climb the telephone pole. But you might be surprised at an answer, because the applicant may very well say, well, I know that you use bucket trucks to access this facility and I can get into and out of the bucket, so I think I can do it. The short answer there is, don't assume that somebody can't do the job until you have made a good faith effort to find out, because you might be surprised. And Lou is going to talk in just a couple of minutes about the interactive process by which you do that. Now, there are other things, like the seizure disorder, which are not going to be obvious. I have had this happen. Suppose you are either in the interview process or an existing employee comes to you and says, look, I can't work in an office which has fluorescent lighting. It makes me sick. You've got to change out all the lights. I will tell you that my first reaction to that one was, you got to be kidding. Well, the answer is, you don't have to be kidding, because when we asked for medical documentation for that condition, we got a very nice letter from the employee's physician with citations to the medical literature explaining that there are people who react to fluorescent lighting. And in fact, it was a reasonable accommodation to swap that lighting out so that her seizure disorder would not be triggered. Coming back to the whole issue of essential functions, let us suppose that you find that an employee or a job applicant cannot lift weights of more than 10 pounds. Well, if the applicant is looking for a job working on a moving truck, moving furniture, that is probably not going to be a qualified disability, because sofas weigh a lot more than 10 pounds. If, on the other hand, that employee only has to lift weights of more than 10 pounds intermittently, it may be a reasonable accommodation to get another employee to help. And this comes up frequently in school situations. As many of you in public schools know, limitations of space often mean that art teachers are what are called itinerant teachers, or art on a cart. They will have a cart full of art supplies and they will roll it into a classroom, and then they will unload the stuff and do it. Well, those carts can be pretty heavy. You may have a terrific art teacher who simply cannot push or load that cart. The essential function of that job is to teach art. An inessential function is to move it around, but it has to be done. What would be a reasonable accommodation? Get a custodian to push a cart down the hallway. In terms of accommodations, the accommodation has to be reasonable. And that really means two things. One, the accommodation can't impose an undue hardship on the employer, which sounds great until we tell you that the threshold for an undue hardship is generally, before the EEOC and the SDHR, so high that you don't automatically want to decide that a proposed accommodation poses an undue hardship. That's something that you really need to have counsel about. The other thing, and this is more important, is the accommodation does not necessarily have to be the first accommodation that the employee requests. The employee may request an accommodation which simply goes beyond what is reasonably required to make it possible for him to do the job. And while the medical documentation which you request may have a proposed accommodation, that doesn't mean that it's the only accommodation. I am going to suggest here, though, because this is something lawyers learn, we may play lawyer, but we don't play doctor anymore. When it gets down to what would be a reasonable accommodation, if it's been proposed by doctor number one, we are not going to reject that out of hand, generally without advice from doctor number two as to what might also work. I want to touch briefly on light duty. You'll see this in the book, and it's another lengthy discussion. Employers are not required to create light duty jobs, but if you do have light duty jobs, you may have to make the light duty job available to an employee who is disabled from a full duty job. You also, if you have a light duty job, may be obligated to give it as a temporary accommodation because people have temporary disabilities. That's another whole discussion. But what I want to end on is no matter how good your analysis is, and no matter how open-minded you are with respect to the need to accommodate a disability, you're going to end up in trouble unless you engage in what is called the interactive process. And that is the critical thing that any discrimination agency is going to look to in evaluating it. So I will turn to the most interactive person I know. That's Lou. He loves to interact, and give him the floor.
Thank you, Jeff. As always, it's a pleasure to work with you. So let's talk about that interactive process. But before we do, I just want to give you, I'm a very visual guy. I love demonstrative exhibits to prove our case, picture worth 1,000 words. When I think about reasonable accommodation, I think about the statue of Our Lady of Justice. It's a symbol you see on the bottom of the Law and Order television episodes. You know, it's a woman with a long robe on, flowing sleeves and robe. She's got a blindfold on her eyes. She's got scales of justice in her right hand, sword to enforce justice in her left hand. So that is a perfect Norman Rockwell drawing in my mind of non-discrimination, which we often talk about. Adam and his group often talks about on this program. So the statue is blind, treats everybody under the law, weighs the facts, is not taking into account illegal characteristics or any other types, rich, poor, black, white, old, young, everybody's the same under the law, right? That's non-discrimination. When we talk about reasonable accommodation, we're talking about something different. The statutes that we're talking about do have non-discrimination provisions. We can't treat disabled people differently than non-disabled people, but in addition, they have a reasonable accommodation element, which is much more than non-discrimination. It's, I know it's an overused term, but it's really requires affirmative action by employers, affirmative duty to do things. So if we try to use that same icon of the Lady of Justice statue, we would say that in a reasonable accommodation setting that's been triggered by the things Jeff just talked about, somebody with a qualified, an otherwise qualified person with a disability, we would say she puts the sword down and takes the blindfold and tips it up and looks with one eye at what is the problem that this applicant or employee has? What's the nature of their disability? What is the problem, the physical or mental problem they have that limits their ability to do certain things? Then she puts down the scales and she picks up the other side of the blindfold and she looks at the job and says, what are the essential elements of this job that an employer needs to be done reasonably? And she's looking at the limitations and the requirements, and then she rolls up her sleeves and she says, I'm going to go to work and try to see if we can make this work. I'm going to see if we can accommodate that job to these disabilities and have a successful disabled employee do the work within certain range of issues. Now, one of the things that Jeff talked about was the interactive process. It's really normally triggered by a request by the employee for a reasonable accommodation. So assuming you run through whether the person actually has a covered disability, which is pretty broad under New York state law, it's broader than the ADA. The ADA is, mental or physical impairments which interfere with a major life function. Under state law, it's really any diagnosable condition, even if it's temporary. So it's very broad. New York City statute is even broader, if it can be broader. So the good chance the disabilities are covered. We've got a request for an accommodation. Well, what does the interactive process mean? Basically, the interactive process means we're going to have a dialogue. We're going to talk to the employee. We're either going to talk or write the employee and ask what the nature of the problem is, describe the problem for me. There's no obligation that the employee define the accommodation. The employee's only obligation is to tell us it's a medical condition and he or she needs some help. There's a problem with me doing this job. Somebody asking for a chair because their current office chair is uncomfortable without more doesn't trigger anything, right? That's a personal preference. On the other hand, if they say I need a chair because I've got an injured back, that triggers the reasonable accommodation interactive process. And basically the interactive process is a dialogue between the employer and the employee, and it's important that we document that. The cases go both ways on whether you can have an independent violation. I think the vast majority of the cases indicate it's not an independent violation, but it will be considered. I've had several jury trials with disabilities. One of the issues that the plaintiff's lawyers have raised is whether there was an interactive process, whether we engaged in the interactive process. And it's an indication of whether or not we've complied with the statute, although it may not be an independent violation. In the EOC's instructions to its investigators, this is one of the specific questions the investigators are told in a reasonable accommodation request to make sure they investigate. What did the respondent do in response to the charging party's request for reasonable accommodation? I.e., did the respondent engage in an interactive process with the charging party? And if so, describe both the respondents and the charging party's actions and statements during the process. This leads to a very important point when you have a disability discrimination case. One is it's a lot different than other cases. First of all, disabilities are something that every person either has experienced or has family members or close friends that have experienced. It's in the tens of millions of Americans that are disabled, maybe 100 million. So there's that issue. It's a common problem. Second, usually the plaintiffs are sympathetic people. They have some kind of a disability that impairs their ability to leave a totally normal work life and personal life. So these are sympathetic people. Our actions and our statements, as the EOC directs the investigator to look at, are going to be very important. The optics, especially of a refusal to accommodate, are very, very important as to all the steps and measures we took to see if an accommodation can be made. And we're only limited by our imagination and the employee's imagination as to things that might work that are doable. They're not limited to quality or quantity. I've had arguments with the EOC that this can't be an essential function that needs an accommodation because it's only 2% of the time that the person spends working. When they do that, my examples of quantity are, on a flight from New York to San Francisco, which I recently took, was about a 6-hour or so flight. Now, landing the plane is only a few seconds of that flight. But if you told me that an airline pilot can fly a plane, he just can't land it, I'd say, well, I don't care how much of the flight the landing part is, very important to me. and it's essential, okay? The person's got to be able to do it, all right? Same thing with firefighters being able to carry people out of the building, a burning building, going down a ladder. When the EOC of the New York State Division of Human Rights says to me, well, how many times does that happen? Well, if it happens once in a firefighter's lifetime, it's going to mean somebody died or lived. So it's something that's essential to the job, and it's not something somebody else can just pick up for them. So quantity and quality don't play a part in deciding what's essential and how reasonable accommodation works. The aspect of not creating an undue, so we're going to, during that interactive process, we're going to want to make sure that we document all our efforts, everything we've done, everything we've tried. And if it's creating an undue hardship or it's not reasonable, we want to be able to show that. We want to be able to carry our burden of showing that in front of a jury or a judge or a Human Rights Division investigator or an EEOC mediator or anybody else that's going to be second guessing our decision. So we want to be careful. We want to document. We want to make that extra mile. Remember, it's not a question of slashing our sword with a blindfold on. It's a question of rolling our sleeves up and saying we really tried to make this work to the extent we could without changing the nature of the business or creating an undue hardship. On the undue hardship side, keep in mind that it's a very limited opportunity. It's going to involve a number of facts, many of which, if you choose to utilize that defense, are probably things, if you're a private business, you're not even going to want to disclose in open court. You're not going to want to get into how much money you pay everybody. You're not going to get into your profit and loss. You're not going to want to get into all the financial aspects of your business that indicate something was going to cost you too much money. The prime example of this, I think, I've ever seen is one of the lead cases on undue hardship under the statutes with respect to an accommodation was a case where City of Baltimore, 3 people who were blind applied for social services intake specialists who would interview people, fill out an application, and start its processing. And these were like grade 19 clerks, administrative clerks. All 3 were blind that applied for the job. Their accommodation they requested was you hire, because I can't fill out the application because I'm blind, I can do the interview, and you hire 3 grade 9 clerks to actually fill the application out, lower level administrative staff that can fill out the form for me. The defense was, well, instead of hiring 3 people for the job, we'd have to hire 6. And by the way, we had a $300,000, I'm sorry, we had a $3 million deficit last year on a $300 million budget or something like that. And the federal court said, you know, another 3 million or another 300,000, I'm sorry, I think it was 300,000 to hire the extra 3 people, 6 instead of 3. The extra 300,000, if your budget deficit is in the millions, what's another $300,000 among friends? That's not an undue hardship. That's just more money that it's going to cost you, not really a financial hardship. I think that shows the depth to which, the difficulty to which there is to proving undue hardship from a financial standpoint. I'll stop there. Accommodation requests should be handled expeditiously. They should be documented. They require a lot of effort. They shouldn't be ignored. They can cause you great problems in terms of disability discrimination claims for a refusal to accommodate. I'll stop there. Thanks, Adam.
Thank you so much, Lou and Jeff. Great presentation. If anyone has any questions, feel free to reach out to Lou and Jeff. Also, feel free to get a copy of the book because I know that reasonable accommodations and the interactive process are covered in that book. Thank you all for being with us this Tuesday. We will see you again next Tuesday. Have a great week.